I'm Jessica Linder-Gallo. I'm the President and CEO of the Aurora Regional Chamber of Commerce. Today, we're here to talk about returning workers to the workplace in the age of COVID-19. And this is part of our Impacts to Employers series that we run throughout the year. So really excited to have a couple of speakers with us who we've had a couple of times. So Julie, Rebecca, thanks for being here today. I'll give you a little bit more information about them here in just a second. So I'll be moderating today's webinar for us. I want to go through just a few more housekeeping items. So like I said, today's webinar is being recorded. So you'll get this recording after the webinar. It'll also be posted online, so you'll be able to share that with colleagues that you think would need to see this content as well. You'll also likely notice that your video is turned off and microphones are muted. That is just to make for the best viewing experience for everybody on the line today. If you have questions throughout the webinar, go ahead and encourage you to just put those in the chat box and use that function instead of your microphone today. So with us to talk through reopening and returning workers to the workplace is Julie Proscia and Rebecca Dobbs. Julie is a partner with SmithAmundsen out of St. Charles, Illinois. Julie provides labor and employment counsel that is outcome-based. She works with private sector businesses of all shapes and sizes, public entities, municipalities, and not-for-profit organizations. In 2012, Julie was honored as one of the 40 attorneys under 40 in the state of Illinois to watch by Chicago Lawyer magazine. She was elected to the Illinois Super Lawyers Rising Star list in 2011, 13, and 14, which was soon followed by her selection to the Illinois Super Lawyers list consecutively from 2015 to 2020. Prior to joining SmithAmundsen, Julie practiced at a Midwest-based boutique labor and employment law firm. Preceding that, Julie worked in the Human Resources Department of Northern Illinois University as the Assistant Director of Affirmative Action and Legal Compliance. With us also is Rebecca Dobbs. Rebecca is also a partner with SmithAmundsen's Labor and Employment Practice Group. She's based out of Milwaukee, Wisconsin. As a former human resources consultant that worked with a variety of businesses in different industries, Rebecca has a unique understanding of the legal landmines her clients face every day. She focuses her practice on employee benefit compliance, administration, and litigation, including COBRA and HIPAA compliance, deferred compensation plans, ERISA fiduciary obligations, and ERISA litigation. Rebecca was selected to the Illinois Super Lawyers list of rising stars consecutively from 2013 to 2017. We'll send you both of their bios after this webinar as well, so you can learn more about them. Point being, these are two amazing ladies that are incredibly knowledgeable on this topic as well as many others in the labor and employment field. So definitely going to get some good information today. After Rebecca and Julie present, we will open up for Q&A via the chat box. So throughout today's presentation, feel free to be dropping your questions there, and I'll moderate after they present to make sure that those questions get answered. So we'll keep an eye on them as we go through. But without any further ado, Julie, Rebecca, I'm going to go ahead and hand the reins over to you.
Thank you so much. It is a pleasure to be able to come in and speak today with everybody, and that was a lovely intro, so thank you. You missed out on the most important part, though. I have the pleasure and privilege of serving as the Chamber's board attorney, so that is actually the most important, or at least my favorite part of that component of it.
That's our privilege.
So what we're talking about today is reopening our economy and returning everybody to work. And that is something that is really on everybody's minds now, how to get our employees back safely and healthy and be able to engage in business again, and how are we able to do that. And what we want to start out with was just an initial thought process, and that is that reopening is going to look different for every business in every jurisdiction, in different countries, in different counties, and even from business to business, from a restaurant to a manufacturing plant. So there isn't a one size fits all. What we're looking to do today is really be able to figure out ways to comport with CDC, IDPH regulations for how to reopen business, how to do it effectively, and how to do it safely. And when you're looking at it, things are changing as COVID evolves, or as hopefully COVID devolves within our communities. So the reopening guidelines are going to be ever changing. So first, we're going to start off with the basic premise of do you have a right to require your employees to come to work? Do you have a right if, the state, locality, city of Aurora says, you could return to work? Do you have the right as an employer to say, yes, you have to come back? And this is a good premise question, because this is a question we're getting all the time, because employers want to know, because people have fears, legitimate fears about returning to work. And the answer is yes. Once the state, locality, municipality says, well, it's yes, but. There's always a but, because we're lawyers and there's always a but. Nothing's ever black and white. So once the state or local municipality says that, yes, we are open and available to allow work, to allow your business, essential or non-essential business, to open, we have the right as an employer to say, you need to return to work. But my yes, but is, we can't go back to business as usual. So the yes, but is, we need to follow the guidelines that are set forth for safe reopening. We can't just throw the doors and go back to what we were doing in February. And we need to have our workforce ready to be able to do that. And we can then, once we have the systems in place, if the individuals don't qualify for something else, like childcare related issues, individuals run the risk of forfeiting their unemployment benefits if they refuse to come back to work. So when we're looking at the phases, and I wanted to start that out in the premise of, we have the right to open our businesses again once the stays are lifted and are lifted. So once we're doing it, we need to look at what the phases are. So the phase that we're in Illinois, and this phases out different in different municipalities. Chicago is a little bit different than what we have in Kane County, which is different than they have in Orange County, which is different than they have in Broward County. So we're in different spaces in the U.S. The CDC recommends that businesses remain closed until they can implement a number of safeguards regarding the state of COVID. So that's the just because you can doesn't mean you can component of this. What that means is that we have to be able to, if we're bringing our workforce back, ensure that to the best of our ability that we have healthy hygiene products available and practices available. What does that mean? That we have to be able to, if we're having people come back into work, have Clorox, Purell, and the non-name brands related to those, so that we can have individuals have the ability to use disinfectant wipes, to be able to have soap, to be able to wash their hands, to have access to it. We have to be able to stage our areas so that we have intensified cleaning and infection. If you're going to have customers come in and meet in the conference room, that conference room needs to be cleaned before and after to make sure that it's sanitized, so that the next individuals don't come in and touch the conference room. We have to be able to ensure that we have social distancing. We have to make sure that people aren't sitting on top of each other, that they're not one-on-one, that we're able to stagger individuals and have them 6 feet apart. And what that means is that we might have to stagger things like when people work. We might have to, the hours that they're there, or the hours of meetings, or stagger things like when they're coming to work. So maybe some people work Monday, Wednesday, and Friday. Maybe some people start at 9, so that we don't have individuals all either coming in the building at the same exact time or sharing the same space. And a lot of times that means that we have to restrict some spaces so that we don't have cubicles that are butting up against each other, or we're constructing things like plexiglass. And we need to train all individuals on safety actions. So what do we do if somebody, if we're taking temperatures and somebody has a temperature of 100? What do we do if somebody feels ill? What do we do if somebody sneezes on us, type of thing? We're not physicians, but we need to follow the CDC, the state guidelines for what we need to do to ensure that, that we're safe. And one of the things that the CDC says, and I think it's the first thing that the CDC says, is that while we can return to work, individuals who can still work remotely should still be allowed to work remotely, to ensure that we don't have an influx and a clogging within our buildings. So when we're looking at safety measures, one of the first things that we're talking about is PPE. And I'm not talking about face masks yet, because we'll do that, but PPE in particular, and what we need. So it depends. So when I said that the reopening in the country is not a one-size-fits-all, is doing it based off of your geographic area, your county. That's really how it also is for businesses, because we need different things for different individuals. So when I say OSHA may require PPE, it depends on what the hazard of the job is. You know, somebody who is taking pictures at a resale shop when nobody's around, we don't necessarily need to give them PPE other than they would have their mask present. That doesn't mean sanitary things like disinfectant wipes and things wiped down, but different PPE. It doesn't necessarily mean they would need booties or anything like that. But individuals who have a higher level of exposure, individuals who are out taking temperatures of people, of your workforce coming in, or clients, may need to have different levels of PPE. And that is really going to be determinative based on the position, based on their exposure and their level of contact, their hazard level. And when we're looking at all of this, we always need to keep ADA in mind, right? So that individuals may be able to request accommodations based on their disability. Like, I can't wear a face mask or covering because of a condition of asthma that I have, because of X, Y, and Z. And at that point, we need to go through the interactive process to make a determination what we need to do. If we need to put the person on a discretionary leave, if we need to isolate them. So these are different things that we need to look at. One of the big concerns that has been coming up for purposes of individuals coming back to work is a fear of public transportation. And while individuals who are in the Aurora regional area don't have this quite as much as other individuals, we still do have individuals that are using CTA, that are using Metro to come in, and a lot of us have offices in other locations. We are not required as employers to provide public transportation or to buy transportation to assist with an employee's commute. However, and this is a big however, we have to be sympathetic to, we have to be understanding of our workforce's fears, particularly about public transportation, and come up with creative ideas. Carpooling is not necessarily a creative idea because we still have people in close contact and proximity, not the 6 feet. But it's things like, okay, assisting them with parking benefits and payments so that individuals don't have to necessarily take the Metro, and then maybe shifting their work schedule so that they don't have to drive in the heart of rush hour, or allowing individuals to work remotely some days a week, or allowing individuals to work at off times when they're coming in so that transit times on public transit are less packed and less jammed, so that we could give some flexibility to individuals.
If I can add one thing, Julie, here.
Oh gosh, please do.
I always want to mention it's an opportunity to bring it up, and you're talking about these additional considerations like childcare, to you're about to talk about, and transportation. One thing I want to mention is Section 139 of the tax code. Sounds exciting, right? No, just kidding. So for those of you who don't have the tax code memorized and know automatically what Section 139 is, it's something that is invoked right now just because President Trump declared it a national disaster back in March. So as of March 17th, and the disaster, the worldwide pandemic is still, ongoing designation, as long as that's in place and the Stafford Act is invoked, you can utilize Section 139. What does that mean for you? That means if you want to give something extra so people can pay for parking or for extra childcare costs or things like that, you don't have to set up a fancy, detailed benefit plan that would, involve all these tax issues. Instead, it can be done with a short memo where you give extra money for people coming in each day, and it's done tax-free. And the reason it's a huge deal is that not only do you not pay payroll taxes on it, the employees don't get taxed on it, and you can still claim it as a deduction, as a business deduction. So there is like Julie said, you're creative. For those of you that are interested, I can get you more information on that. Or Julie can, but it's just, it's a huge, easy way to do it. And it's also nice because it's tied to the pandemic, so it expires when the disaster designation is revoked.
It's a really, really good point. I'm glad you brought that up, because we need to be cognizant of the concerns of our workforce. So if there's anything that we can do, particularly things that don't cost us anything, to ensure that we have a safe workforce, a happy workforce, then we should try and at least look at utilizing those type of measures. Along that lines, while I said that we can require our workforce to come back, we have to be cognizant that a lot of individuals might not have the ability to work not remotely at this point in time. So there are going to be a lot of childcare issues, and are a lot of childcare issues, because even though as of whatever date your county is in, for us, May 29th, June 1st, we were able to and eligible to open most of our businesses. That's great, but a lot of childcare facilities are not open. And when childcare facilities are not open, or let's say the individual stayed with the grandparents, but you can't have the individual stay with your grandparents anymore because they're in a high-risk group, people don't have a place to put their kids. And so if put their kids, it makes it exceptionally and exceedingly hard for them to be able to work. Very problems occurring, right? At that point in time, we could turn to other things. And one of the other things that came into play with the FFCRA in the beginning of the pandemic, one of the first things that was passed under the CARES Act, was that individuals can have up to 12 weeks off total, the expanded FMLA, in order to stay at home with their children because of childcare related issues, i.e. your daycare is closed, your school is closed, and that those individuals would receive pay at a reduced rate, most of the time at a reduced rate, up to $200 a day. And so we would request documentation that their place was closed, and that documentation can be, just an email or correspondence. I'm at ABC Daycare, Childcare, and ABC Childcare facility is closed due to further notice. And then those individuals would be able to receive the FFCRA leave. That leave is, and this is kind of like going back to the Section 139 plan, that leave is 100% deductible for you on a quarterly basis. So this is something that, again, costs you nothing to that point. And so you'll be reimbursed with that. And you have the option as an employer to make a decision whether or not you want individuals to use that as a block, or if you want to have individuals use that as on an intermittent basis. Like let's say, well, I can work from home 4 hours a day, but and only 4 hours a day because my spouse works from home as well, so we could block it off. Or I could work from home Mondays, Wednesdays, and Fridays, and on Tuesdays and Thursdays I have the childcare related issue, or on Mondays and Fridays I could come into the office. So you have that option, and that's dependent upon how disruptive it is to your organization. What I would strongly encourage individuals to do is to pre-plan all of this for our businesses. Again, it's not a one-size-fits-all thing, but it is really difficult for, let's say, if we call up our employees on Sunday and say, we are reopening on Monday, you need to be here on Monday, for them to rearrange childcare related issues. So the most amount of time that we could give individuals, whether that's a week or 2 weeks, to arrange that really is amenable, and will make individuals grateful. This is a challenge that's going to be for everybody, for us to accommodate individuals. And it may be that, we have to do staggered return dates. So I kind of wanted to go through the beginning of, what we need to think about. We need to think about the physical proximity of individuals, right? The social distancing. We'll need to figure out the construction, and we'll talk about more about that later. Putting up plexiglass, individuals, putting signs on the floors that say 6 feet apart. Sometimes cutting off the communal things like coffee pots and things like that. And then just getting things ready, right? So you need to get things ready. You need to ensure that you have childcare, or that we're doing things for FFCRA. Well, now what happens when we have people start coming in? So the EEOC is permitting individuals to do temperature and symptom checks, and that is actually something, while not required, that is recommended by the Illinois Department of Public Health. And some localities and states are also mandating it. So because we have businesses in different offices in different cities in different states, you know, you need to check where you are. And we've developed, numerous entities have developed different checklists for individuals when they're entering the site. Have you had a fever? And then, you know, have you had a cough within the past 24 hours? Things like that. Temperature checks are allowed by the EEOC, and they're recommended by IDPH and by CDC. The temperature checks need to follow ADA requirements when we're looking at them. And ADA requirements say it must be job related and consistent with business necessity. In the age of the pandemic and COVID, individuals entering a workforce in a communal area would be consistent with, it would be required for the business, or a business could requirement. We should notify our employees beforehand that we are going to be doing temperature checks of all employees prior to their coming in. And there's no one size fits all. Again, I've said that like 4 times, so like I beat that horse dead. Some employers are saying do temperature checks at home, and if your temperature is above 100, don't come in. Some employers are doing the temperature checks on site. It really is a matter of your preference for how you want to do so. But we need to ensure that our messaging is clear, that we are not doing so to be invasive. We're doing so to ensure the employee safety, our customer safety, and our client safety. And that just because we've taken the temperature check, that is not, this is my good legal disclaimer, a substitution for a clinical diagnosis, right? We're not doctors. All we're doing is reading the temperature gun and saying if it's above 100 and below 100, right? That's all we're doing. So we need to take that into consideration and ensure that, you know, and there have been individuals who have been asymptomatic who are carriers. So this is not a guarantee that you're not going to have individuals who are symptomatic, or who are carriers within your facility. This is one tool we have in our toolbox to check, to ensure. Again, just like when we're talking about PPE, when we're talking about different face coverings, you know, that we have to find out if there's a medical requirement or a face-based requirement why an individual would not want to have their temperature checked, and then go through a reasonable accommodation accordingly. If you're going to do temperature checks, you have to make sure that you have the logistics down in order to do this. Because if you have, let's say, a manufacturing plant with 100 people coming in, you have to ensure that there's logistics, right? So you might have to stagger your workforce so you don't have 100 people standing out in line. Where are you going to do that? You have to ensure that there's confidentiality, that we're not like, okay, this guy's a 101, and so that everybody knows their medical condition. This has to be information that is kept confidential. Who's going to do this? You know, we have to make a decision whether it's going to be somebody who's designated as our employee, or whether it's going to be designated as another individual, a third-party vendor. Are we going to be consistent? Do vendors and visitors also have to take the temperature? What kind of temperature tests are we going to take? You know, there are the very fancy heat screens where you just walk in front of it and it takes it. There's the guns that, you know, you could take it from a number of feet distance where it'll read the temperature check, but, you know, those sometimes are problematic in super cold weather or super hot weather. You know, there's also the oral temperature checks, which none of you should be using, because I don't want to stick my face and hand in anybody's face. I mean, there's the disposable ones that you can hand individuals that they put on their forehead. So there's different routes that you can take in order to do it. And this goes back to when I talked about the different levels of PPE for individuals who are actually doing the testing of the individuals have to get close depending upon what means and method you use. So they might need more PPE. You know, they might need something, and you might feel that they need something like a face shield on top of the mandatory mask that you have individuals wear when they're in your facility in any type of common or communal space. And those individuals you have to think about are also at higher risk for infection. So you might not want to put and designate an employee who's at a high immunocompromised risk factor as the temperature taker. I mean, these are just things that we want to, take a look at, not just what devices, but what they need to wear and how we want to do it. Again, logistics are going to be really important with this. If we're going to have 100 people lined up outside, then we need to make sure that we have tents or things that, so that they're not out in the rain or out in the cold. It does no good to have somebody take their temperature when they've already walked all through our factory and got into their location and then taken off their jacket and changed in the locker room and then came there. They have already spread whatever it is that they were going to spread throughout your whole entire factory. So where are we going to stage that? If we have people massing outside before we take temps, we should probably mark on the ground what 6 feet apart is, so people aren't bunching together, and then have individuals who are, who are essentially policing that, who are saying, like, you guys need to take a step back, it's not 6 feet apart. So what happens if your employee has symptoms of COVID-19 and they're not diagnosed yet? So if somebody comes to work and they say they're symptomatic or they have a temperature, we need to tell them to go home immediately. Don't have them finish off their shift and then send them home. And I'm telling you, there's like at least 3 people on Zoom right now that were like, what? But I'm telling you, if I didn't hear it at least 50 times already, I wouldn't say it. Have them go home immediately. Again, it does not help to have them all around and doing everything and then send them home. Do not allow them to return to work until they've been symptom-free without medication for 72 hours and 10 days have passed since the onset of symptoms, or medical professional certifies that they do not have COVID. Now, I'm going to give a big caveat with that, in that, again, as throughout this whole entire pandemic, guidance has been changing. So this is the guidance that we have as of June 2nd. So we need to keep continually changing things. If an employee tests positive or there's a presumptive test, even if they're asymptomatic, our local health department will likely say that the employee can return usually in about 14 days. And that goes with the above, right? Because it's not 14 days, but they're still symptomatic, or they still have a fever. And so it's 14 days usually is by the time it'll crest. When we're looking at when an employee comes in, so that was the employee comes, they're symptomatic, either they've got a cold or a cough, or their temperature popped over 100, we send them home, right? So do we need to pay them during this time? The answer is probably, depending, maybe, kind of. Think of it like donning and doffing time. If you have 100 employees who are waiting outside and it takes a half an hour for all the temperatures to get in, yeah, you do. If you have 3 employees and it takes 2 seconds and it's minuscule, likely not, because it would be considered de minimis type of time. But if they're filling out a survey every single time and it's taking 20 minutes, again, that would probably require some type of compensation. When we're making the decision, not just to compensate individuals, but whether or not we screen them, we want to, and we find out that something, that an individual is symptomatic, we need to, again, like we said in the beginning, we need to keep that information confidential, and we need to keep it separate from their employees' regular personnel file. Think of it like any medical documentation. I can't tell you how many times I have, my clients have received a personal records request, and I have my clients send it over so we could go through it before we send it to the other attorney. And I'm like, why are there mammogram results in here? Like, there's no reason the mammogram results are in there. It's the same thing. This is their medical diagnosis. It shouldn't be in there. And we also shouldn't be telling everybody that Bob Smith just tested positive for COVID. Individuals who were exposed in direct contact, we will let them know that they were in direct contact. We're going to re-clean the areas that they were in, or the facility, in a total, but we're not going to make an announcement and a memo that Bob Smith was, Bob Smith flagged 100 and danger, Will Robinson, because we have to protect their confidentiality as well. when we're keeping the information, we really only need to keep it as long as we're managing the COVID-19 risk, and then it should be permanently deleted. So real quick, when we're looking at this, HIPAA likely is not going to apply. Why? Because for the most part, we are probably not covered entities. We're not medical providers. Now, the difference is if we have an employer-sponsored health plan, and that may come into play. But BIPA, which is our biometric laws, may come into play depending upon what type of tests you're doing, what type of screening you're doing. If you're doing fingerprint scans, that would qualify. Just the temperature scan would not qualify. So at this point in time, I'm going to turn it over to Rebecca, who's like, for the love of gosh, please stop speaking.
It'd probably help if I unmuted. Good afternoon, everyone. Okay. The next slide is we really get a look at these. You basically is you want to have help. Julie and I were talking about how that training requirement is still there and everything that we're dealing with now. And when you're training on anti-harassment, this includes no discrimination for national origin or ethnicity. Okay. Let me make a little personal here. So I am half Chinese. My mom is from Hong Kong, right? And so picture this little frail, well, she'd probably kick me in the face if she heard me describe her this way. But this Chinese little, tiny little Chinese lady who really doesn't get it because she's probably been living in this country for 50 years, okay? At least 50, 60 years. So she goes to the Y to work out before this, it was closed down. And apparently people in the facility were telling her that she should go home, like to her country when she's lived here 50 years. Like, this is a very real thing. And maybe I see it even more being in Wisconsin. For those of you who didn't hear, I'm based out of the Milwaukee office. So things are a little less diverse in Wisconsin. For those of you who haven't heard, nobody's wearing their mask at the Walmart either. It's a little bit different up here. But the point is that it's real. People have these judgments. We're seeing this play out now. Like, you can't just ignore that these type of stereotypes and judgments and discrimination are happening, now more than ever for a whole bunch of different reasons. But that is the gist of it, is don't forget that, this is an area ripe for discrimination. I also find how employees are behaving is very different too, because, I don't know, I feel like all this work from home we're losing our social skills. How do I flip? It's not flipping. Julie, can you help me, please? Okay. Yes, you could pass through this because I am explaining that already. Okay. So the other note, and you will get a copy of these slides as well, so don't be like, oh, I wanted to see that example with xenophobia and 2 Asian employees. Don't worry, I'll get it later. But that is just the gist of the discrimination component of this. Now, what about people who are scared? Not just of people of certain minorities or ethnicities being contaminated, if you will, but also the idea of, I don't want to leave my house now. This is not safe. It's been, fear alone is not protected. Okay. So what I will tell you, if for those of you on the call, I'm guessing most of you have already sat in the seat where you've called someone and they're like, well, I'm scared. Are you sure we should come back? This matter. I don't want to leave. The thing is, in my opinion, is that you ask why, right? So are they scared because they don't have someone to watch their child? Well, then we talk about the childcare issues that Julie brought up, right? Where then you have to deal with those things and what's coming up with COVID and FFCRA leave. Are they scared because they live with someone that is immunocompromised? Do they have other issues that you want to try to possibly work with? Or are they just, losing their mind and they're scared to leave their house, which is not protected? But my point is ask the questions. You do want to know. And if they have no real protected reason under FFCRA leave or anything like that, and you need them to come back to work, you can't accommodate telecommuting because, you know, it's the barista, like Julie mentioned, then you're going to document that it's considered abandoning their job, resignation, whatever you want to refer to it as. You're going to want to report that to unemployment. For those of you with PPP money, that's a requirement that you ask them to come back. And if they turn it down, that you report that to unemployment in order to not have your forgiveness prorated. You have to take that into account and have the conversation. Now, if someone just thinks it's not safe, you shouldn't just get fed up, because I know it's a bit stressful for all of us, and it's easy to get a little ticked off when someone else is questioning whether you would really open up a place and jeopardize everyone, okay? But you have the conversation. Explain why it's safe. Explain the science. And don't just fire them for asking the question, right? Retaliation is not okay. And I will tell you that we have had a significant increase in OSHA complaints. Because if you push your employees and you don't listen to their questions and address them, even if you do and they don't like your answers, they're calling OSHA on you. Customers are calling OSHA on you. OSHA is getting a ton of stuff. I've had clients, and when they get that OSHA complaint saying, we've had a report that your workplace is unsafe, they then, you have to scramble and submit all your written protocols and everything to them, and answer all their questions to be done. Can we switch it, Julie? So you want to make sure that you address it. You have multiple moving parts here. Now, with OSHA. Now, speaking of that, what if an employee is in contact with someone at work who's diagnosed with COVID? Okay. What I want to mention here is that it is not, contact is an interesting term. Like, you have to know the science here, right? This whole thing has become a ginormous political football, and it's not. It's just about science and dealing with things. So there's a huge, ask the questions. I'll give you an example. I had somebody ask me a question. They're like, well, we have an employee who came into contact with someone who was diagnosed with COVID. Who is that person? Oh, we found out it's his sister. Oh, we found out he lives with her. Okay, so now this standard of 14 days, he can't just quarantine for 14 days, because think about this. Unless you know that she's also quarantining and they're separating from him in their living situation, then he continues to be exposed to it every day until she stops showing symptoms. So you have to have conversations with your employees, and you can now under the ADA. You can ask these questions because you have to protect everybody else at work. So whatever that means, and the standard on getting testing to be released back has changed because of the availability and access of it. But you want to make sure you address those. If you want to flip slides, Julie. And again, this goes to my example goes to typically the individual will be out until symptom free for at least 3 days, 72 hours without medication, and 10 days have passed from first day of symptoms. But keep in mind that this is if somebody, that's for the person's sister, right? So these designations without testing developed by the CDC because we had a lot of people recovering at home, and we needed to figure out when it was safe, a general accepted standard for them to be released out into society again, okay? So if you're following the CDC targets, which are moving targets because we continue to learn and learn more about this disease, if you're following that, you want to then, you're acting in it's a standard of care. For those of you who are involved in healthcare at all, right? It's what's normal. If you engage in the normal standard of care and monitoring things, then you don't commit malpractice, right? So it's the same kind of thing. You're not having an unsafe workplace by OSHA if somebody had COVID and you followed those guidelines before you let them back, which is what you care about. OSHA's deferring to CDC, and they're talking together. And again, this goes to the OSHA and COVID guidance, because they are working with CDC. I talked to one of our partners that handles a lot of our OSHA work, and he's like, I never had to look at CDC guidance, and now I look at it every day. He's like, I'm on the website every day checking the different guidance because it is changing every day with what we know. But the thing is you want to be following it, monitoring it, using the tools that are available to monitor when people come back, when people don't come back, and document how you're following it. There are forms and flow charts and all kinds of things on the website that they modify or change and continue to add. You can use those to develop and model a work protocol, a safety and that. Switch it. Workers. One thing I mention here probably gets COVID. You have to show that it was work related, and this ties to the OSHA reporting as well. So what this means is it refers to a questionnaire. We have a sample one on the next few slides that we'll get into, but that you'll be able to get when you get a copy of these. But asking the questions, taking the temperature checks, like Julie mentioned. If you're doing this, the logic would be, well, how did you get this at work? And also, let's not freak out that it's the end of the world if it is something covered by workers' comp, because remember, in most cases, this is not a fatal incident, a fatal injury, and also it's usually a temporary claim in terms of lost benefits. Okay, Julie, if you want to switch, I don't know why my control. Yes. Okay, you can go through the next few of these. These are general questionnaires that you'll have to take home when you get a copy of the slides. You can see some of the sample questions and customize this for your workforce. This is an example where the employee is filling out the form and turning it in. This is also an example, but it's confidential, right? This is something you're keeping internally to kind of track what you're finding about the employee, an employee who's out. This is if somebody got diagnosed with COVID, did you inform their coworkers, the ones that were actually in close contact, which means they were within 6 feet for 10 minutes or longer. We've learned a lot about the virus since, and it's not quite as easy to catch as we thought it was initially. So it's not just passing by them in the hall. Again, confidential checklist. This is something to go through if you are going through that, oh my gosh, Tom called and he's COVID positive, because you'll want this handout to refer to later, because that's just how it works, right? You don't really absorb it until you have to, and then it'll be like, oh shoot, what did Julie and Rebecca mention I should be asking? So we have those slides.
So I'm just going to jump in for a second and say, sorry, Rebecca, that I think that the use of the checklist is not just good for the employee, but it's a good touchstone for both employee and employer for purposes of just grounding things back down, because there's been, a number of times when I've had a client call, and because it's scary and it's changing, and we get that, right? Where we've had clients call and say things like, oh my God, Tom tested positive of COVID. What do we do? Like, I need to tell everybody in the workforce we need to disinfect. And I'm like, haven't you been remote? Hasn't the whole office been remote since March? And they're like, yeah. I'm like, then we don't need to do anything. Tom hasn't been in the office for 2 months, and nobody has. It just kind of grounds it, because I think that everybody's first instinct is to panic, because you're like, oh my gosh, but Susie lives with her parents and her parents are ailing. It's just a way of not just helping us with liability, which is a very good thing from the employer perspective, but also grounds it back down to, like Rebecca was saying, the science.
Yes, the science, the things that you should be thinking of. When's the last time they had contact with anyone? And walking it back a little bit calmly. So likely lawsuits related to COVID-19. Okay, because you know that there are going to be a slew of litigation after this. People not paying wage and hours right, not handling leave laws correctly, how the FFCRA, I know Aurora Chamber has done webinars on that. Julie has, I have with her for some of them. The leave available, not following those, that's a wage and hour violation for part of it under the Fair Labor Standards Act. Retaliating whistleblower, OSHA retaliation, right? If you're complaining about an unsafe workplace, you're protected under OSHA. ADA, reasonable accommodations. I had, whether it's a significant impairment to be immunocompromised, something like that, and an employer not allowing the work from home situation. That's a big one where people are still wanting to drag everyone out of their homes, and I get why, but in some cases it's not necessary. And you got to have a business need for, creating these group environments that the CDC is not a fan of. Warn, there were exceptions for pandemics in terms of it not being foreseeable, but at this point, it's kind of foreseeable. Like, we have an idea of what's going on. It's not an unknown. Like, we're at a different place now that we were in March. We still don't know what's going on, but it's not so, it happened yesterday. Now it's been going on a few months. You know that this is going to keep happening, and we're waiting for a vaccine and other things that are going on. So is it foreseeable? Becomes the issue. And if you have employees talking together, discussing terms and conditions of employment, that's protected activity. So firing someone for that, for sticking up for each other, trying to talk about different terms, that's going to be retaliation under the NLRA as well. This one, public relations media inquiries. Because if you have, or maybe I'll put it this way. Okay, it seems like a pain to have to deal with the CDC guidelines, to develop workplace protocol, to, deal with Tom, who's really just making up excuses about his mom having COVID when you and I both know that she doesn't, or something like that, and you're trying to manage things and you see the abuse out there, and it's easy to get annoyed and want to push people back to work and do whatever. But trust me, it sucks for the people who have a COVID positive employee and they haven't taken like crazy diligent steps, and then they're on the local news, right? And now you're that restaurant that opened back up and your bartender is on the news for having COVID, and you're like, oh great, guess what? Your sales are going to be an issue. That's not great for your marketing campaign, right? It kind of hurts the whole reopening strategy. So you really want to be cognizant that this is a big issue. And if someone reaches out, make sure you get help. Okay, don't even pay attention to this slide. Just think, we need to call someone, because it's a delicate situation on how to handle the media. Okay, waiver for employees, not a good idea. You can't, when workers are injured at work, the exclusive remedy is workers' compensation, and you can't waive your workers' comp rights. In some cases, it can also be criminal to try to have them waive those rights. So a lot of them aren't enforceable, and they just create a bad vibe with your employees that you have something to waive. Next. Waivers for customers. That could work. It can happen, but you have to be careful. For example, in Wisconsin, I can't, if I have a place where I'm inviting guests on, there's a Safe Place Act, something like that says I can't delegate my negligence responsibilities and my responsibilities to guests. But the question becomes, can you do like Disney, right? And some of you may have seen Disney kind of started this where they're having guests waive their liability just in regard to COVID exposure. They're still doing the body scans and infrared temperatures and all of that stuff, but their waiver is, from what I understand, very uniquely tailored. Next. These are samples for you to take home when you get a copy of this. Sample reopening guidance. Again, but what I would emphasize is you look at this in terms of remembering the general framework like Julie mentioned, because a lot of this is stressful, but make sure you look at the CDC website because it varies by industry. Initially, it's broken down by if you're, have people just interacting with each other, if you're customer facing, if you're in manufacturing, things like that. So you really want to look at these kind of things. And Julie mentioned a lot of them, like shared coffee maker, water cooler, those kind of things, not a good idea anymore. Travel restrictions. I think it is also a good, foreign travel isn't exactly, we're not welcome in some areas right now. It's restricted travel anyways, but if and when that happens, or even traveling to different states, if you have a concern with that, make sure your employees understand that, they have to disclose it. If they do travel and it's an area that's higher risk or with community spread, that you can certainly require them to quarantine for 14 days. Just the fact that they're using an airplane or whatever, traveling in that mode, and that'll be at their own expense or unpaid. So I don't know if you all saw the guide, and they showed that Ozarks party with all the people like, woohoo. And then of course there was a COVID exposure, and you saw the one guy who's like, if I'd have known I was going to have to quarantine for 14 days, I would have never done this. You're like, really? But you have a policy. My guess is his employer probably has a policy. He probably didn't read it. is my guess. He's probably too busy heading out to the Ozarks, but whatever. So that was him. Have your policy. And in conclusion, and I'll invite Julie to chime back in here, you know, you got to be fluid. And I hate that. I hate saying it's unprecedented times or we're all in this together, right? At this point, I want to punch someone in the face if they tell me they're in this together with me, because it's a little frustrating. But we really want to stay fluid is the key, to recognize that this isn't, you know, the world. You're not setting precedent. These aren't permanent policies. This is just getting through the situation. We're dealing with Band-Aids right now and trying to use the right first aid kit to get through to the end. Do you have any questions?
Awesome. Well, thank you so much, ladies, for the great information. We have had a few questions come in during the presentation. So we've got just a few minutes left here. Let's see what we can get through. So one of the questions that came up was, are there repercussions for an employee if they certify that they don't have a fever before coming to work, then they come to work and do have symptoms or do have a fever?
So it depends. Yeah, like, how are you going to prove that they didn't get the fever, like that the fever didn't manifest if they say they took their temperature at 6 o'clock and then you take their temperature at 9 o'clock? How are you going to prove that they're lying? So I think if you can prove that they're lying, sure, but otherwise I think that's challenging. Rebecca?
I think you focus on the fact that they have a fever and get them out.
Makes sense. One of the questions was, how often is it recommended to test an employee for a temperature? Once in the beginning, once a day, weekly? Is there a recommendation on that?
So it's kind of across the board. Some employers are doing it. Most employers that are doing temperature scans are doing it prior to the start of every workday and not doing it multiple times a day. So that is the most common that I've seen.
And I think it also depends on your environment, right? I mean, you see some of these issues they're having with meat packing plants and that kind of thing. Are you in a high exposure or high risk environment, or is somebody sitting at their desk by themselves all day? So you just really want to use common sense too. Like, you don't have to act like you're in a high risk environment if you're not. You want to, like Julie mentioned in the beginning, it's different for everybody, and we're modifying things and just transitioning it back as best we can.
Great. One of the questions you ladies covered a little bit, but maybe just some additional information. If someone is refusing to come back to work, what options do you have to get them back?
So
there's not a great answer here.
There's not a great answer. I mean, there are some employers, again, depending upon what your business is, if they're scared because they're going to have such high contact with the public or with individuals, then some employers in the beginning were doing hazard pay. Depending upon what that is, that's hard. It just depends on, you know, what the job is. Giving some type of bonuses for individuals and or incentivizing them with childcare payments, with things like parking. And it's really just, I think, and Rebecca touched on this before, getting to the root of why they don't want to come back. Are you scared because you are terrified to take public transit? I live out in the burbs. Before all this started, I would be downtown 2 days a week. I'm not getting on the metro. So like, okay, but I would have no problems driving into the city and do parking in the parking deck. So in that case, is it the tax credit that would get me to do that? You know, so kind of getting to the root of that.
And, you know, it's not the effective tool because people won't, it's not warm and fuzzy, but it doesn't hurt to mention that, you know, if they just don't want to come back because they don't want to come back, that if they've received a firm offer and declined it, that they could jeopardize their unemployment benefits. Because there are cases where many people are like, no way, I want to keep my unemployment. I'm making more now. It's short-sighted because it's going to run out. But, you know, it's just, it's worthwhile to bring it up. I say you're not going to win people back.
It's the carrot and the stick.
Yeah, you got to be careful how you bring it up because it's truthful and you should warn them. But at the same time, they're not going to come back with smiles on their faces if you take it up, I'm going to go after your unemployment kind of thing. So use it as appropriate and advise them of the consequences of refusal.
That's great advice. So one question that just came up in the chat and is one we heard over and over again in the roundtables we hosted last week really is about COVID testing, not just screening. So if an employee has a fever or they have symptoms, can you as an employer mandate that they get a test before coming back to work?
How are you going to mandate that when some healthcare facilities won't give them the test if they don't meet certain criteria? So that's, I think, the problem is that answer is going to depend on the availability of free testing and it's being eligible for that testing in your community.
Yeah, because so if individuals that are symptomatic can likely get tested at most places, but individuals who are asymptomatic are still being denied tests at certain facilities depending upon who it is. Ones that are run by private companies will test asymptomatic individuals because they make money off of each test. Some healthcare providers will not because of the accuracy of the test for asymptomatic individuals.
All right, so we'll make this our last question here, just in terms of high contact surfaces. One of our attendees asked if they can provide individual water bottles in lieu of the typical dispenser, the water jug that would normally be open that they will likely need to close.
I think that that's a good idea, that if you're going to have customers or clients in and you want to provide them with something, most people at this point in time would not be comfortable with the water jug. Is it ecologically safe, or not ecologically safe? Is it ecologically good? That now we're going to go back to plastic. Well, maybe let's go back to plastic, and just for a few months, as opposed to the communal, water jug that's open at this time.
Awesome. Well, we are just a few minutes after 3 o'clock, so we'll go ahead and get wrapped up here and get you all back to your regularly scheduled work days. So as a reminder, today's webinar has been recorded. We'll be emailing out this link to the recording and the slides from today, so you'll be able to get those sample policies and information that Julie and Rebecca were sharing for access at a later time. You'll also receive Julie and Rebecca's bios and their information in that email as well. So to both of you, thank you so much for being here. It truly was amazing information. I know I got a lot out of it. I'm sure everyone else on the line did as well. So we really appreciate your help with that.